Rule on examination of child witness. This rule shall govern the examination of child witnesses who are victims of a crime, accused of a crime, and witnesses of a crime. The overall objective of the rules are, first, to create and maintain an environment that will allow children to give reliable and complete evidence. Second, to minimize trauma to children. Third, to encourage children to testify in legal proceedings. And fourth, to facilitate the ascertainment of truth. Construction of the rule. The rules are liberally construed for the best interest of the child. This means that in all circumstances, the court must give utmost importance to the following. First, security. Second, protection. Third, feelings. And finally, physical, psychological, emotional growth and development of the child. Who is a child witness? This refers to any person who is below 18 years old at the time of the giving of the testimony. This may also refer to all persons who may be over 18 years old but are mentally or physically incapable of taking care and protecting themselves from abuse. Competency of the child as a witness. Every child is presumed to be a qualified witness. However, the trial court judge may conduct a competency examination when substantial doubt exists as to the ability of the child to perceive, remember, communicate, and distinguish truth from falsehood. Summary of these rules. Examination shall be conducted by the facilitator appointed by the court to pose questions. The child should testify in open court, but may also be allowed to testify in a place other than a witness chair. He must be given an interpreter when needed. He is entitled to a support person who can accompany him during the testimony and taking of deposition. He is not required to look at the accused. The counsel should not approach him when he is already afraid and intimidated. He must be given a recess during examinations when needed. He must be allowed to use testimonial aids to give him comfort and emotional security. The court may allow leading questions in all stages of examination if the same will further the interests of justice. Questions should not mislead, confuse, frighten, or intimidate the child. The public may be excluded in order to avoid further emotional and psychological harm and to protect the privacy of the child. As a general rule, hearsay evidence is not admissible as evidence, but not for child witnesses. A statement made by a child describing any act or attempted act of child abuse may be admitted in evidence in any criminal or non-criminal proceeding. When the child witness is unavailable, his hearsay testimony shall be admitted for as long as it is corroborated by other admissible evidence. Sexual abuse shield rule. The following evidence is not admissible in any criminal proceeding involving alleged child sexual abuse. Evidence offered to prove that the alleged victim engaged in other sexual behavior. Evidence offered to prove the sexual predisposition of the alleged victim.